Beloved comrades and friends, this is your KVS. In the last episode, we have seen the importance of the trade union and also the role of the trade unionist. In this episode, we are going to discuss about the responsibility of the divisional office bearers and also the activists in protecting the innocent and gullible employees while giving the statement to the officers. Of course, it is a paramount need for each and every division. We should constitute a team of activists, at least a minimum number of 10 for each division, possessing the rightful knowledge on all the topics so that they can rescue our comrades while there is a severe attack from the bureaucrats. It is possible because after 2009, the mass recruitment taken in the postal department consists of more than postgraduates, engineering graduates, and all which is not less than 95% of the total recruitment. We are having intellectual comrades. We have to identify such of those intellectual comrades who are ready to assist, who are ready to work for the union. At least 10 numbers in each division and branch, so that we can form the team, that is the assistance team to the suppressed and the underprivileged. We can form a team in each division. That is very much required at this juncture. Why? Because the attack on the poor GDS employees, the postman and MTS, and also the gullible postal assistants, they are in serious attack continuously by the administration. All of you know very well. Ours is a quasi-judicial. Ours is not a judicial proceedings or judicial inquiry. If it is a judicial inquiry, there is a prescribed punishment for all the crimes. What are all the crimes? They are prescribing the nature of penalties and fine everything, and accordingly it will be awarded. But in the case of departmental proceedings, it is a quasi-judicial. It is not a judicial. It is a quasi-judicial, and the discretion of the officers is playing more havoc and important in those cases. For example, even for a same case, if two persons have been charge sheeted, one person may be awarded with censure and another person may be awarded with a severe punishment. It is possible. It can be given as per the quasi-judicial powers, since there is no prescribed penalty or punishment for each type of mistakes committed by the officials. So this is a lacuna available, and this has been totally mishandled by the administration in many cases. During 2003, there was a Supreme Court judgment. If an officer misuses the quasi-judicial power, he can also be proceeded. Even during 1978, there was an DOPNT order. If an officer making error in judgment, and also if he is acting prejudicial to the interest and also biased manner, he can also be proceeded if the cause is established. There are certain orders also, but you have not seen even a single case of action against the bureaucrats who misused the quasi-judicial powers so far. This is happening everywhere. Though in the quasi-judicial power, the officers are armed. They are armed with more power. Even they can go to any extent. While you are countering with those officers who are armed with power, naturally you should possess a very good knowledge in the disciplinary rulings and as well as the other rulings. The first and foremost important, the statement given by the officials at the time. At the time of inquiry, that is the major item which we should educate our rank and file. One of the officers' association, they have issued a pamphlet to the officers in which they categorically stated that while at the time of inquiry or at the time of preliminary investigation, just to say whatever you want, whether it is true or false assurance, maybe a bogus assurance. You make the people to accept the guilt and try to recover the entire loss sustained to the department by any method. This is the instructions given to the officers. Our innocent people become prey without knowing the rulings. They are simply giving the statement as per the dictation of the inspecting officers immediately. The first statement when we are giving, that is called as a prima facie statement. The prima facie statement is having a major role in the inquiry. Suppose, on the basis of the prima facie inquiry, a Rule 14 charge sheet was framed, and subsequently, during the inquiry, the case is not proved, and the defense assistant has closed the case. Somehow, after the inquiry, the officer's report, it is saying the charges are not proved. Even after that also, disciplinary authority, he can use the preponderance probabilities by saying, I am taking the prima facie statement because that is not tutored. That was given at the time of catching him red-handed, and he has not been tutored at that time. So they used to say that the preponderance probabilities they want to apply in the case, and the innocent official become a victim. So this is happening in most of the cases. Because the first statement, whatever we are giving the first statement, that should be a very good statement, and we should be more cautious in giving this statement. We should not hope the uncertain assurances given by the administration at the time of giving the statement. So we should be more cautious. Our officials should be more cautious. Suppose one officer is coming and asking you to give a statement. Is it necessary to give a statement on the very same day? No, not at all. It can be denied. You cannot give the statement on the day itself. You can say the officer who is coming to obtain the statement, you can say, today I am not all right. I am mentally sick. I am physically sick. I cannot give any statement at this juncture. And or otherwise, I want to verify all the records. I want to see whether I was working on the day, etc., etc. You can put anything else. And finally, you can say, I will give the statement 2 days after or 3 days after, like this. Even after that, if that particular officer insists that you should give the statement on the day itself, before giving the statement, you can make a mention. Due to my poor condition of health, I can give the statement after 2 days, but I have been compelled by the officer, so that I am giving this statement. If you are writing this as a preamble, and thereafter if you are giving the statement, the entire statement becomes void. The entire statement cannot be used further. In some cases, even without giving this, if you are having some apprehension or something else, due to the compulsion, if any statement is given, immediately after giving the statement, you can straight away write to the disciplinary authority. That means the divisional superintendent. So far the PA is concerned, you can write to the divisional superintendent through proper channel that I have been coerced to give this statement which I have not given in sound mind. If you are sending the 2 lines to the divisional superintendent or the disciplinary authority, thereafter through proper channel, thereafter the statement become infectious. It is not having any hold. So it vitiates the entire proceedings. If they want to proceed further on the basis of the statement which has been obtained from you under the coercive condition, naturally the statement becomes invalid. They cannot do anything. So, before giving the statement, one is having the right that I cannot give the statement on today, I will give the statement after 2 days, something. You are having the right. You cannot be compelled. As per the Supreme Court order, no one can be compelled to testify on the very same day. The Supreme Court judgment is very clear. Not only that, even there is no DOPT orders or anything, any orders from any department, that statement should not be refused. No proceedings can be taken for the refusal of statement also. It cannot come under the Conduct Rules 311 or 322 or 333, something else. It is not coming as a unbecoming of a government act or anything else. So you need not worry. You cannot immediately, you need not give statement. You can collect all the particulars and thereafter you can discuss with the knowledgeable person of your team. That's why I am saying, from the beginning I am insisting, each division we should have a team, a knowledgeable team we should create, we should formulate. Actually, the affected official should immediately consult, and so that the reply will be, the first statement will be properly coined and properly given. Thereafter, at the time of inquiry, it will be more useful to anyone. This is very, very important so far these I am saying, because this is, I have told you the prima facie statement, the first statement given at the initial time, that is more valuable at the time of inquiry, even after completion of the inquiry, before awarding the punishment. So be cautious while giving the statement. And at the time of giving the statement, one has to check whether they have actually performed duty on the very same day. For suppose, in most of the head post offices earlier, there were in arrears in RD compilation, RD posting, and even in SB posting also, or MIS or whatever it may be. There were delays during those days. Even very prior to computerization, we can point out, there were delays. Suppose on the particular day, whether you have worked in the branch, whether you have actually dealt to the cases, dealt to the particular posting, something, you are having the right to verify. You are having the right to verify, and you can definitely question. And also, at the time of giving statement, you are having the right to see the original. I will not see the photostat copy of the document, which I cannot believe like this you can take. As per the orders, it is very clear. Even at the initial stage or at the inquiry, they should produce the original document at the time of obtaining the statement. So, at the time of obtaining the statement, simply on the belief of the Xerox statement and also the person who is bringing the document, please don't give statement. You can say, I want to see the original, I want to check the original. After checking the original only, I can give statement. You can definitely say. It is very clear in our volumes. Even in volume 3, it is very clear, even at the time of inquiry, not at the preliminary stage I am saying, even at the time of inquiry, they have to produce the original document. For that only, there is a provision. In case of any fraud or suspected any contributory negligences on the part of any official, they should show the original in advance at the time of the preliminary investigation itself, and they should show the original and get their signature obtained for having seen the document at the time of the first investigation itself. So thereafter they cannot produce anything. Even it is in the court of law, they have to produce. They have to produce the original documents in the inquiry. That is one of the vital points that has not been changed so far. So at the time of giving the statement, you should be more cautious whether you have worked on the particular day, whether the work was carried by you, whether is there any other official responsible. In case if any official is responsible, who are all such officials and what is the role and responsibility, you have to make everything in your memory and thereafter you have to give the statement. So giving statement is the very important work for which a team in the division is a must for everybody, I am saying. And also, so for the statement given, I have told you what are all the precautions to be taken, and generally whatever be the pressure and whatever be the circumstances, without verifying the valid documents and records, don't give. And if they are insisting without the valid document and others, it is against the principle of natural justice as per Article 311 of the Constitution of India. We are actually armed with the principle of natural justice. I will deal all the principle of natural justice in a separate class, and it need not be mingled in this class. So you should be very cautious at the time of giving the representation, number one. And second, the official can give any representation, and some of the officers, suppose a person who is giving the representation to the concerned, either to the SSPOs, and if there is no reply within 3 months or 6 months, he is again sending a reminder, and also Nietzsche, they are writing it is copied to the DPS or copied to the PMD, Chief PMD or something else. And immediately those officers may ask, you are violating the channel of communication, and without, you cannot directly correspond to the Director of Postal Services or PMD or something else, they may ask you also. Under the circumstances, you should know what is the ruling provision. Whatever be the representation of an official, it should be replied within 30 days by the department. By the concern, it should be replied within 30 days. If it is connected with 2 departments, a consultation is required. Suppose a case which requires a consultation with the DOPT, it may take 45 days. If consultation of 2 departments are required, the time period fixed is 45 days in such cases. In rest of all the cases, the time limit is only 30 days and they should give you a reply. In case, if they could not give you a proper reply within 30 days, the department should give you an interim reply in which they say at what stage it is pending and when you are going to give the reply. If they fail to give such a reply to you, they cannot prevent you for further appealing to the higher-ups. That we should know, because suppose we can use the RTA also in such cases. Suppose you are making a genuine representation or you are making a genuine appeal. All the appeals and all the petitions that should be transmitted to the next authority within 45 days from the receipt of the such appeal or petition. Suppose if it is not forwarded within 45 days and your appeal is delayed for more than a year or more than 6 months or 7 months, you can ask the information under the RTA. Please intimate the date of disposal of my appeal. Please intimate the time limits prescribed for forwarding the appeal. Please intimate whether there is any delay in the particular office, and if so, who is responsible. Please intimate for making such a delay what kind of action is proposed as per the rule. Likewise, you can put so many questions. and make the department to work actually. You can use the RTI. That is also one method. When you are making an RTI, you should be certain in your side, and there should be no lacuna or no problem at your side. Such a cases, you can use the Right to Information Act also, and which is also one of the major thing for this. And also the individual representations. Sometimes the divisional administration, when you are taking up a case in writing to the divisional administration, they can say the service union is precluded to take up the individual cases. But it is not. Service unions are precluded to take up the individual cases only in the formal meetings. Formal meetings as a specific subject, you cannot take up such cases. But in correspondence, they cannot say that you cannot take up the individual cases. There is a very specific order in 1976. Service unions are not precluded to take up the cases. Even the excessiveness of the officers, that can be discussed with the next higher officers, that can be given in writing by the union. Unions are not prevented to make a complaint against an officer who is functioning as an unbridled horse type. They can be put under the check. They cannot run amok as they like. They can be put under the check. The trade union is having that power, and they can definitely write such correspondence, and it cannot be taken as a individual correspondences. So the trade union has enormous things. Now today, I want to confine my presentation today only with the statement and representation. When statement, we should be more cautious. And thereafter, when there is a charge sheet memo or Rule 16 or anything else, how we should prevent ourselves, that we are going to discuss in the subsequent episodes. And in this episode, I am insisting, my dear beloved divisional secretaries and branch secretaries, to form a team in your division and branch. Please do it. There are people, there are volunteers, there are people, more people who want to assist others. The younger generation want to assist the fellow comrades. They are possessing ideas, they are having wisdom. Just kindle it. They will become the very best warrior for the trade union. We can make use of it. So I am requesting you, please form a team and be careful while giving the statement. And also in representation, if there is no response to the representation, you immediately go for the next step by making further appeal, representations, as well as using the RTI and everything. So with this, I am concluding this episode, and we will meet in the next. Goodbye, viewers KVS.